అందెలమెక్కిస్తుంది, కీర్తిని గుప్పిస్తుంది. చదువుకునే రోజులు అందరికీ అందితే జీవన సౌదాలు, అందరికీ అందితే జీవన సౌదాలు. థ్యాంక్ యూ.
Thank you, sir. One more song by Venkatachari, sir.
On behalf of All India Lawyers Union, Telangana State Committee, I am welcoming you all to this national seminar, Constitution and We the People. I am C. Ramachandra Reddy. I am Secretary of Hyderabad Committee of AILU, All India Lawyers Union. It is a pleasure for me to invite all of you for this national seminar on Constitution. You know well, all of you have registered your names for this program, entire day-long seminar, which is most crucial topic nowadays. Constitution, what is the present trends and all that. The different dignitaries who are here, who are present here, they will enlighten all of us about the basic features of the Constitution and the present situation and the structure, federalism and secularism. Different topics will be taken up in 3 different sessions. Primarily, initial session, the inaugural session will be our Honorable Justice Lao Nageshwara Garu is here. We are very happy, fortunate Justice Lao Nageshwara Garu here. First of all, I request our Sri Kolli Satyanarayan Garu, President of All India Lawyers Union, to come over onto the dais. He is President of All India Lawyers Union, Telangana State Committee, and he will preside over the inaugural session. I request the Honorable, our Chief Guest, Justice Lao Nageshwara Garu, former Judge, Supreme Court of India, to come on to the dais. We welcome you, sir. Justice Lao Nageshwara Garu was advocate here in our High Court, late Supreme Court advocate, and then became the Supreme Court judge. And we all very well aware of Justice Lao Nageshwara Garu. We are welcoming Justice Lao Nageshwara Garu, who will be the chief guest, who will inaugurate this national seminar on Constitution and We the People. I request Sri A. Ananthareddy Garu, A. Narasimha Reddy Garu. I request Sri A. Narasimha Reddy Garu, Chairman Bar Council of Telangana, to come on to the dais. Okay. Please welcome, sir. Please come. Sri K. Parthsarathy, our State General Secretary, All India Lawyers Union, who is also General Secretary of the Reception Committee. So I request him also to come on to the dais. And so I understand that Mr. B.S. Prasad Garu, because he is unwell, he could not come down to this program as of now. And Sri Vinod Kumar Garu also, the MP and Vice Chairman, Planning Commission of Telangana State also, he could not immediately come over to this program. Friends, in the part of the continuation of this program, this inaugural session, that's Honorable Justice Lao Nageshwara Garu will be dealing with revisiting the basic structure of the Constitution, and then the other 2 topics, primarily the second session regarding the federalism in constitutional framework and present scenario. Mr. Durga Prasad Garu will preside over, and Mr. John Brittas, MP Rajya Sabha, and Justice T. Rajini Garu will be addressing us on federalism in constitutional framework and present scenario. And subsequently, the third session in the afternoon will be secularism, 7 decades of judicial interpretation. It will be chaired by Srimati Shailaja, Advocate, Women Convener, AILU Women Committee, Justice S. Muralidhar Garu, Honorable Chief Justice Retired, Chief Justice of Odisha High Court will be addressing us on the topic. So I welcome you again, once again. I request our President, Sri Kolli Satyanarayan Garu, to proceed with the program. Thank you very much.
I request Sri Narendra Reddy Garu to offer a bouquet to Sri Justice Lao Nageshwara Garu. I request Mr. Praveen to come and offer a bouquet to Sri A. Narasimha Reddy Garu, Chairman Bar Council of Telangana. Good morning, friends. I take the opportunity of inviting all of you to have a rather a refreshing class of Constitution of India, because this is being the seminar organized by All India Lawyers Union. We felt that the area of working of Constitution for the long 77 years had given such a result to the common public, who are expecting much basing on the Indian Constitution, because unlike other countries, it is the Indian citizens who have taken the Constitution on their own. So the very preamble of the Constitution says that we, the people of India. So that is the gist of the Indian Constitution, which promises to the common citizen of India, basing on the entire composition of Constitution, is going to show that basing on that Constitution, the people should live in India by providing all the required amenities, living life, and the guarantees which are given by the Constitution. And we all know that Indian Constitution have a good number of articles where the preamble of a Constitution is going to show or reflect with regard to the democracy, socialism, secularism, and we as a lawyers union are working for those three issues. And as we lawyers, we have also incorporated the justice in our aims and objectives. And All India Lawyers Union have its own constitution, and we function basing on the same contents of the preamble, and also the guarantees are fundamental rights which are to be reached to the common public. So we are struggling not only for the advocates' welfare or the community betterment, but for the betterment of the entire society and the common public. So this is the social activity also being taken by the AILU. That's why we have invited citizens of this city also to participate in this seminar, apart from the advocates. So on behalf of AILU, I feel that this is the right time to examine the Constitution and its functioning for the last 77 years, the working of Constitution. We accept that for the last long 77 years, the people have received some fruits basing on the functioning of the different governments, but whether the fruits those were reached to the public are on par with the guarantees given by the Constitution or not is to be verified. So this is a progress card which we have to take with regard to the service that is being given by these respective governments to the common public basing on the Constitution. So previously in the year 2016 also we did the same exercise, and Justice Gopal Gowda was the chief speaker on that day, and he spoke on the subject. And after a gap of 7 years, again we are conducting this seminar. And unfortunately, All India Lawyers Union is conducting these type of seminars in the entire India. In all the states we are conducting these type of seminars, and in Telangana now today we are proceeding with this, and we have divided the subject into 3 sessions, and I request all of you to participate in the 3 sessions. And before calling our chief guest to address all of you, I request Sri A. Narasimha Reddy Garu to come and address all of us.
Today's chief guest, Honorable Justice Lavu Nageshwara Garu, retired Judge, Supreme Court of India. My good friend, Kolu Satyanarayana Garu, President AILU, TS Committee, Parsardi General Secretary, and all other distinguished personalities who are in this session, inaugural session, and also my dear advocates, brothers and sisters. I am personally delighted to have this opportunity to participate in the national seminar on Constitution and we the people. We, on behalf of the State Bar Council and on my personal behalf, I would like to thank the All India Lawyers Union, not only for taking up this special program and also having invited me to this session. As we all know, the All India Lawyers Union has been active since its inception in the year 1982, playing an active role in highlighting the basic issues relating to the provisions of Constitution and the manner of their implementation for the benefit of the citizens of India. The selection of the main theme of this seminar, Constitution and we the people, is commendable and deeply significant. We are aware that the Constituent Assembly with the Dr. Ambedkar as a chairman of the drafting committee prepared the draft and same was approved and came into force in the year 1950. As Dr. Ambedkar stated, the recommendation of the adoption of the Constitution, the underlying philosophy of that, ensuring the theory of equality, liberty, equality and fraternity within the framework of democratic republic state. As the preamble envisages, we the people claim the sovereignty of the nation. The system of universal franchise reiterates and gives concrete shape to the unique features of our Constitution. We as a nation feel proud that it is the same, the people, we the people, who have contributed to the sustainability and access to our democratic system. We are now the largest democracy in the world. We should appreciate the role of All India Lawyers Union in striving hard to highlight the problems faced by the people within the framework of democratic framework of our Constitution. Issues relating to the fulfillment of directive principles of state policy, rule of law and human rights are taken up various levels. Through the system of universal franchise, has provided for political equality, while the continuing social inequalities pose a big challenge. As Dr. Ambedkar said, we should strive to ensure social justice in order to strengthen the political democracy. The term "we the people" is also a reminder of our diversity. We are a nation of many different backgrounds, cultures and beliefs, but we are also a nation united by a common set of ideals, liberty, justice and equality for all. Before I conclude, I would like to say a few words about my relation with the All India Lawyers Union. Since its inception, when I came into Bar Council, not only as a member, thereafter vice chairman, chairman, from the beginning, the AILU was supporting my ideas, and fortunately, Koli Satyanarayana also was one of the members, really working hard to, not only for this organization, and also strengthening the system of our council. So we have same ideas, and a like-minded, any program for that matter, we were together, and always I used to support AILU because my main intention is that I came from village background. So once I entered, it's our prime duty, Bar Council prime duty, to go legal education programs. So sometimes I find it was very difficult to take up the programs on my own along with the members of Bar Council. Certain issues were very to take up. So always I requested Koli Satyanarayana garu, Vidyasagar garu, let us work together. They also say, they used to say, let us do this, that. We used to work like that. So only our intention is to educate the advocates about the various issues, subject like this, today's program. And so my personally I feel that this is an occasion to say a few words about our chief guest, Lav Nageshwar Rao garu. After a long time, I attended one program of him. I think Justice Nageshwar Rao was one of the, he was a chief guest in M.R.K. Chaudhary garu's junior, Nageshwar Rao garu. At the age of young, he expired. Memorial lecture was there in the public garden. So Ganta Rama Rao, being a vice chairman and my colleague member, informed that, sir, let us go to that program. Myself and Prakash Reddy and Rama Rao went there. I surprised to see that how much he developed the subject, I cannot even express in words. Nearly 3 hours, 4 hours discussions and deliberations. Honorable Justice Nageshwar Rao garu could not get the time, proper time for the inaugural speech, whatever the final chief guest speech. So ultimately, he has to reach the airport within a period of one and a half hour. So being a last speaker, he started giving the lecture. I never forget in my life. Even Prakash Reddy, being his colleague in Supreme Court also, he expressed lot of, so only by God gift we'll get that knowledge. On that day, continuously, he made a speech, really wonderful speech. That's how I never forget his speech. So, he himself present in this seminar to give his speech. Really, everybody is fortunate here to hear his speech. And thank you very much, sir, for having given consent to be here in this session. I'm glad to see that eminent practicing advocates and legal experts and the intellectuals are here to participate in today's seminar. I'm sure that the deliberations will be fruitful and the purpose will be served. Thank you, one and all.
Today, our Honorable Sri Vidyasagar and also the should be among, but due to his other circumstances, he had been to US. So he sent a message which will be displayed to all of you to look at this. I request the organizers to display the.
Yes, sir. Yes, sir. Yes, sir. Okay. Yes, sir. Yes, sir. Yes, sir. Yes, yes.
Okay, he's not connecting with the online, and I request Sri Arun Arjun to read out the message sent by Sri Vidyasagar Garu.
This is the welcome address by Sri Hon G. Vidyasagar Senior Advocate Garu. I am reading it out. It gives me great pleasure to speak to all of you this morning as President of the Reception Committee of today's National Assembly, Constitution and We the People, organized by all the lawyers union, Telangana State. To avoid compelling reasons, I am physically not present, but thanks to technology advancements, I am addressing the same from San Jose, California, USA. This event of organizing the joint efforts of AILU, Telangana unit for last 2 months under the guidance of Mr. Kolli Satyanarayana, President, and Mr. K. Pardasarthi, General Secretary of the unit. We, the people of the country, have enacted the Constitution for our country and brought it into force on 26 January 1950. The Constitution enumerates legal rules and principles which govern the government of the country and fundamental law of the country. Time of its adoption by the Constituent Assembly comprising of eminent personalities in all walks of life. The basic philosophy of our Constitution is the preamble to the Constitution, we the people. Therefore, we have chosen to organize the seminar on this topic, which will be relevant for all times to come. In the recent years, we are witnessing a significant change in our country in all the three wings, namely judiciary, legislature, and administration. Justice L. Nageshwar Rao Garu, Supreme Court Judge retired, was kind enough to accept our request to address the seminar on the topic, revisiting the basic structure of our Constitution. Mr. John Brittas, Member of Parliament, and Srimati Justice T. Rajani on the topic, Federalism in Constitutional Framework, and Mr. Justice S. Muralidharan on Secularism, 7 Decades of Judicial Interpretation. All the dignitaries have accepted to participate in spite of their busy schedule. The Advocate General, Mr. B.S. Prasad, has been kind enough to be in the forefront in encouraging the organizers of the seminar. Distinguished invitees, members of AILU, and all participants are requested to participate in the seminar and contribute to the consolidation of aims of AILU in organizing such seminars. I am confident that everyone here will be benefited by the presentation by the distinguished speakers on various topics and broaden our perspectives. In conclusion, I thank one and all who have contributed for organizing a seminar of this magnitude. Thank you.
Thank you, Arun. I request Vadasarthi Garu to give some welcome remarks for 2 minutes.
మిత్రులారా, ఈరోజు రాజ్యాంగం పైన పెద్ద దాడి జరుగుతున్న తరుణంలో ఈ సెమినార్ని ఆర్గనైజ్ చేయటం అవసరం అనేది మేము ఈ రాజ్యాంగాన్ని రక్షించుకోవటమే ప్రధాన లక్ష్యంగా పెట్టుకొని ఐలు పనిచేస్తున్న పరిస్థితి ఉంది. అందుకు అడ్వకేట్స్తో పాటు వేరియస్ ఫీల్డ్స్లో ఉన్న ఆల్ సెక్షన్స్ ఆఫ్ పీపుల్ని కూడా మొబిలైజ్ చేయడానికి కొంత ప్రయత్నం, చిన్న ప్రయత్నం చేశాం. ఇది సరిపోదు. భవిష్యత్తులో దీన్ని పెద్ద ఎత్తున ప్రజల్లోకి తీసుకుపోవటానికి, అవగాహన కల్పించడానికి ముఖ్యమైన ఉద్దేశంతో ఈ సెమినార్ని ఆర్గనైజ్ చేశాం. కాబట్టి నేను ఎక్కువ సమయం తీసుకోకుండా ఒక 2 నిమిషాల్లో పూర్తి. Guest on the dais, respected friends and members of the legal fraternity, and other secular democratic citizens who are present here. I, on behalf of All India Lawyers Union, Telangana State Committee, welcome you all. Today we are passing through a stage where a foundational document of our governance, that is Constitution, is in danger, getting undermined, getting undercut from within. For more than a decade, there are several attempts to assault on the Constitution. it appears for a common observers that a parliament has right and authority to amend the constitution to meet the changing times. What times have changed since the adoption of the constitution? Does we eliminated poverty completely? Does we could provide employment for all able, educated and qualified? Are we able to feed the hungry stomachs? Recently, National Family Health Survey report revealed it recorded that more than 52% of our population, particularly women, are anemic. Then what is the need to change the overall law constitution, which we adopted to govern the country till we overcome all the problems issues just mentioned above? It is more astonishing that a parliament is being used merely as an instrument to carry forward the non-parliamentary undemocratic agendas set out by some sittings somewhere. It is in this context the AILU decided to work towards strengthening the constitution and also by generating the awareness about the constitution and its role in our daily lives and also in the life of the nation. It is with this aim and understanding we are organizing this national seminar today here. We are all thankful to the speakers who are graciously accepted our request to present their thoughts on various aspects of the. I personally, on behalf of AILU Telangana State Committee, warmly welcome Sri L. Nageswara Rao Garu, former Judge Supreme Court of India, who is known for his apparent and unequivocal stand on certain constitutional issues. I also welcome John Britta, Member of the Parliament, Srimati T. Rajani Garu, former Judge and Judicature of Telangana and Andhra Pradesh, currently serving as a national member of. I also extend special note thanks to Justice Muralidhar Garu, who recently retired as Chief Justice of Odisha High Court. He made his mark on both on the bench and bar since the days he took up the Bhopal gas affected people's issue. This endeavor could not have been made possible without generous support and extended by several individuals, legal numerous, senior counsels, and especially Advocate General, Government of. We extend our warm gratitude and regard. Thank you.
Now it is the time for inviting our chief guest, Sri Lau Nageshwara Garu, Justice Sri Lau Nageshwara Garu, to address all of us. Before that, a small request with the Justice Nageshwara Garu, because press people are pressurizing for release of souvenir before your speech, for ceremonious release of souvenir, because it's not yet completed, totally completed, not, but now I request Sri Justice Lau Nageshwara Garu to address all of us.
Mr. Narasimha Reddy, Chairman Bar Council of Telangana, Mr. Sachinarayana, President AILU, Mr. Pardasarthi, and my dear advocate friends, a very good morning to you. When Mr. Pardasardi came and met me and asked me to address on basic structure in a seminar to be organized by AILU, I was telling him that it might be difficult for me to come in view of so many engagements, but when he said that there will be a large number of advocates who would be interested in learning about the Constitution and the basic structure, I was also thinking that I should somehow or the other make time to come and share my views on the Constitution with you all. I appreciate the efforts of All India Lawyers Union in conducting a seminar like this, in trying to create awareness not only in the legal fraternity but also amongst the citizens about the Constitution and what it says and what it is for. I'm also told that AILU conducts regular workshops for lawyers even in the districts, not only restricted to Hyderabad. I'm very happy to learn that an academic exercise amongst lawyers is being conducted by AILU. There is something which is lacking in the Indian legal profession, which is there in most of the developed countries, that is continuing legal education for lawyers. We do not update ourselves as legal professionals with the development of law. We come out of law colleges, stop reading books. We only thrive on practical experience, and most of us also experiment on people who come to us with their briefs. It is high time that the lawyer should realize that they should be well equipped, at least with the branch of law in which they are practicing. Having said this, I am asked to speak on this topic of revisiting the basic structure. As it's a mix of lawyers, citizens, and lawyers practicing not only in the High Court but in the civil courts, I will tell you the story of basic structure. That will be, I think, a better way for all of you to understand what this basic structure and the Constitution is all about. After a long struggle for independence, a time came in the 1930s where there was a talk of India becoming independent from the British yoke. The Government of India Act 1935 was passed, giving limited rights to people of India, elections being conducted in the provinces. It would be interesting to learn that it was only persons who were graduates and income tax payers who were permitted to vote for elections under the Government of India Act 1935. Then a constituent assembly was constituted. This was in the United India, where Pakistan was also a part of India. Elections were conducted, and in the elections about 350 people were elected to the Constituent Assembly. Most of them were from Congress. A few of them were from the Muslim League. Persons who came from the Muslim League wanted a separate Constituent Assembly for themselves. They said, let there not be one Constituent Assembly. And thereafter, as you know, there was partition, and the Independence of India Act was passed. There was an indirect election to the Constituent Assembly which had about 295 people. And this Constituent Assembly was the Provisional Parliament. As you all know, 14th night, it was the 15th of August 1947, when India became independent. But prior to that, in 1946 December, the Constituent Assembly started functioning. The Constituent Assembly appointed a drafting committee under the leadership of Dr. B.R. Ambedkar, who studied his law in UK. And Dr. B.N. Rao was given the task of drafting the constitution and placing before the drafting committee. Dr. B.N. Rao visited various countries in the world, and then he borrowed provisions from the US Constitution, Irish Constitution, principles from UK, the Weimar Constitution, which is a German constitution. They even took provisions from Switzerland and then, well, Russia also. And there are some smaller known countries whose constitutions were read by B.N. Rao when he made recommendations as to how this constitution of India has to be. After about 3 years, almost 3 years, 2 years, 11 months of discussions, after the preparation of the constitution, the Constituent Assembly approved the constitution on 26th of November 1949. 26th of November each year is celebrated even now as the Constitution Day, because that is the date on which the Constitution was passed by the Constituent Assembly. Though it is not connected to the basic structure, the final speech that was made by Dr. Ambedkar on 26th of November 1949 is memorable. He said, "We are politically independent now. People can exercise their votes to elect people, their leaders. People are now governed by themselves. You do not have a foreign power governing. But the question remains as to whether we have really got independence." He said, as long as this country is divided on the basis of caste, religion, and region, there is no independence. At that point of time, there were about 3,500 castes. He said that unless people rise above these vociferous tendencies, there will be no independence in India. And he said that a country that is going to be governed by ourselves is going to be a disaster, and there is no complaint that we can make against anybody else. At least earlier, we could complain against some foreign force ruling us. So, gentlemen, ladies and gentlemen, keep it in mind. All of us are educated. All of us at least project ourselves to be civilized. It is high time that we rise above all these considerations of caste, religion, and even the disparity in the society also has to be forgotten. All of us are equal. I'll speak more about it when I come to the preamble of the Constitution and the provisions of the Constitution. So the Constituent Assembly completed its job. It finalized the Constitution. And 26th of January 1950, you know, that is the Republic Day. On that day, the Constitution started working. Elections were conducted for the first time in this country in the year 1952. And Congress went to polls by saying that there is going to be a social revolution that will be brought by the party. They said that agrarian reforms would be there and justice would be done to a poor man in this country. On this promise, elections were conducted in 1952. Congress came to power. At that point of time, it was still the Constituent Assembly, which was the provisional parliament which was taking decisions. The Zamindari Abolition Act was passed. Zamindari Abolition Act was challenged in the high courts of Bihar, Madhya Pradesh, and Uttar Pradesh. The Bihar High Court struck down the Zamindari Abolition Act. The Madhya Pradesh High Court and the Uttar Pradesh High Court, they upheld the Zamindari Abolition Act. Zamindari Abolition Act was struck down on the ground that it violated the fundamental right of property. persons who had a right in property approached the High Court, and the High Court upheld their contentions that it was violating their fundamental rights. The Supreme Court had to take up the first case insofar as the Zamindari Abolitionist Act is concerned, and it was a judgment, if you can note down, Shankari Prasad. I'll just mention about 4 or 5 judgments. I'll not trouble you mentioning about too many judgments here. If it was a law college, I would have told you about more judgments on the Constitution. By this time, the Constituent Assembly, which was the provisional parliament, carried out the first amendment to the Constitution of India. By this amendment, there was an amendment that was made to Article 19 pertaining to freedom of speech, and our Constitution, which has about 395 articles and 8 schedules, which is the longest constitution in this world. There's no other constitution which has so many articles. A 9th schedule was added to the Constitution by the first amendment, and the 9th schedule said that any law made by the legislature or parliament, if it is put in the 9th schedule, it cannot be challenged in any court of law, and the court of law cannot set aside or declare it as unconstitutional on the grounds that it violates the fundamental rights. So the 9th schedule was introduced because Pandit Nehru felt that the courts were stepping more than the jurisdiction, more than whatever it is given to it, and when the parliament was interested in making agrarian reforms, the courts have been a stumbling block in carrying out the policies of the government. So the First Amendment was challenged before the Supreme Court. All these judgments of the 3 high courts which I mentioned, which dealt with the Zamindari Abolition Act, were brought to the Supreme Court. Rights that were guaranteed to the citizen are supreme, and they cannot be tramped by the parliament by making amendments and saying that they are placed beyond judicial review. That is, courts cannot look into the laws that are made by the parliament. The 5 judges bench of the Supreme Court said that there is nothing wrong with parliament exercising their power. They upheld the First Amendment, and they dismissed the petitions that were filed in challenge to the First Amendment. Though not again connected to basic structure, the other amendment that was made by the First Amendment pertained to placing restrictions on the fundamental right to speech. There was a case that came from the province of Madras, that is the state of Tamil Nadu, where there was a communist-run newspaper which published some articles against the government, and the government said that they have committed sedition. So the newspaper took the ground that there is a fundamental right of speech, and nobody can stop the press from writing what the truth is. So then the court had to interfere and then say that the act that was made by the government of Madras was in violation of 19. That made the parliament make an amendment to Article 19 by placing reasonable restrictions in Article 19. After the First Amendment was upheld, there was a rush for all the laws that were made by the legislatures to be placed in the 9th schedule, so that it is placed beyond the jurisdiction of the court. Nobody can challenge these laws. The numbers swelled to about 250 laws that were made by the parliament, making these laws go out of the reach of the court's purview. Court cannot look into that law and say that this law is unconstitutional. There was an amendment that was made, which is called the 17th Amendment, again placing several laws from Punjab and various other states, Rajasthan, etc., which was again challenged by people who have properties, saying that these laws that you're making would be affecting our rights of property and our properties are being taken away by legislations. The Supreme Court again met, upheld the 9th Amendment, upheld the 17th Amendment, and they said that the Parliament has the power and there's nothing wrong with what is being done. The judgment of 5 judges was decided with a laser-thin majority of 3:2. There were 2 judges who dissented, and they said that the 17th Amendment might not be constitutional. 17th Amendment was revisited later at the behest of Chief Justice Subbarao, who constituted a 11-judge bench and decided whether the 17th Amendment is constitutional or not, and in a case called Golaknath. The point that was being argued and the Supreme Court was saying earlier was, there is a provision in the Constitution which is Article 13(2). Article 13(2) declares any law that is made in violation of the fundamental rights to be void. The argument that was advanced earlier was that even if you are making an amendment to the Constitution, that would be law falling under Article 13(2), and if fundamental rights are violated, then the court should interfere. Earlier, in Sajjan Kumar, the court said that an amendment made by the Constitution under Article 368 is not law that is mentioned in Article 13. That is a constituent power that is given to the Parliament. So Parliament has power to amend the Constitution. But the 11 judges bench, which was headed by Chief Justice Subbarao in Golaknath, held that an amendment made to the Constitution under Article 368 is also law in Article 13(2). And if any amendment that is made to the Constitution is violating fundamental rights that are given to the citizens of this country, then the court has the power to strike it down as unconstitutional. This is again a judgment of 6 judges being in the majority and 5 judges not accepting what the majority has said. By saying this, the 11 judges declared the earlier judgments as wrong, but it applied a principle of prospective overruling following some American judgments, saying that the judgment that is delivered by the court would be applicable only from that date, not setting aside whatever was done in the earlier judgments of the Supreme Court. Now comes the setting for Keshwananda Bharati. After Golaknath was decided, the government immediately swung into action, and they made 3 amendments to the Constitution, 24th, 25th and 29th amendments. The effect of these amendments that were made, 24th, 25th and 29th, is saying that the Parliament would have power to amend the Constitution in the manner in which it likes, and adding a proviso to Article 13(2), saying that it applies only to the fundamental rights in 13 and not to the amendment to the Constitution, and taking away judicial review. So with these amendments that came into force, a 13 bench had to be constituted because Golaknath was decided by 11 judges. And Keshwananda Bharati, which ultimately decided the basic structure doctrine, went on for about 60 days. Long hearings were conducted. It was decided during the course of hearings of Keshwananda Bharati that the correctness of the judgment of Golaknath is not being looked into by the court, but the interpretation of the word amend in Article 368 was the subject matter of discussion. So we'll have to understand the background of Article 368 and other relevant provisions of the Constitution before we proceed further, how we understand basic structure is all about. Our Constitution, as I said, contains about 395 articles. The most important chapters that we are concerned with here are Part 3 and Part 4 of the Constitution. Part 3 guarantees to all citizens of this country certain fundamental rights which are basic rights for existence of a human being. You have right to equality and equal protection of laws in Article 14. You have the fundamental freedoms in Article 19. You have a right to life in Article 21. And you have other rights which have been mentioned therein. I will not go into all those one by one. And the most important right that is given to a citizen in this country is Article 32. Article 32 is a right that is guaranteed to every citizen to approach the Supreme Court of India for issuance of a writ whenever there is a violation of a fundamental right, assuming somebody is being illegally arrested and his right to life is being affected. Somebody's freedom of movement is being trampled upon. Somebody's freedom of speech is being throttled. He can directly approach the Supreme Court and make a grievance about executive action and say that he has a fundamental right which has to be enforced by a court of law. Dr. B.R. Ambedkar, while the discussions in the Constituent Assembly were going on the fundamental rights, said that if he has to pick up one article out of these 395 articles, which is the most important article in the Constitution, he said it is Article 32, which is the heart and soul of the Constitution, because it gives the power of judicial review. It places checks and balances on executive power and even parliamentary legislation, which means, in simple terms, if there is a law that is made by parliament or a legislature which affects the rights of people and the fundamental rights are being taken away, it is Article 32 and the Supreme Court which can interfere. You have a provision under Article 26 also which confers the same powers in the constitutional courts at the states, which are the high courts. They also exercise the same powers. These fundamental rights are very basic to a democracy. For a person to say that I'm a proud citizen of this country living in a democracy, he says that I have these rights which are not there in most of the countries. I'm a free man. I can do whatever I want. I can say whatever I want without any inhibition. Now comes Part 4 of the Constitution, which speaks of directive principles of state policy. There is a duty that is cast on the state to ensure the welfare of the people in this Chapter 4. Both Chapter 4, the Part 4, which is the directive principles of state policy, and the fundamental rights are like two wheels of the chariot. The state government has to see that the welfare of the people, including those downtrodden people, is taken care of by making laws. Laws that are made under the provisions of Part 4 of the Constitution is only for the purpose of improving the lot of the people, taking care of their health, nutrition, education. Everything is mentioned in Part 4 of the Constitution. The tussle between the Parliament and the court from the beginning has been, the Parliament says that I am making laws under Part 4 to benefit the people. Why should the court interfere on the ground that there is violation of fundamental rights? On the other hand, the theory in the protection of fundamental rights is that there is a basic right that is given to the society as such and individuals, and you could not be permitted to trample those rights. So this is the tussle which is going on. It's a healthy tussle, actually. The question as to who gets supremacy is something which I will deal with a little later. So the balance between the directive principles and the fundamental rights has also come up for consideration in another case, which I just mentioned in another 2 or 3 minutes. We have this provision that permits the Parliament to amend the Constitution in 368. Why should there be an amendment to the Constitution is something which you might ask yourself. Thomas Jefferson, who is a great philosopher, the President of the United States, said that a generation is of 10 years. A generation changes every 10 years. Every generation has the right to decide what is good for themselves. We do not have a right to decide what would be good for people who are going to come into this world after 50 years. The societal changes would be there. Parameters would change. Living conditions would change. Still, the American Constitution has only 27 articles, and it has been there from 1797, except for the Bill of Rights that I mentioned. They say Constitution is a living document. Why do they call it a living document? Because you make a Constitution, and then you apply the principles of the Constitution to changing times. But would there be a need for amendment to the Constitution? There would be. As I just said, that with changing times, changing policies, changing standards of life, there might be a need for the Parliament to exercise this power of amendment. So Article 368 says that the Parliament has the power to amend the Constitution. That power is there. Now, the entire theory of basic structure which I am going to speak of revolves around that power to be exercised by the Parliament under Article 368 of the Constitution of India. And what did Keshwanand Bharati do? Without taking you too deep into the case, what Keshwanand Bharati decided was, there are judgments written, so many opinions were written, even by the majority there were about 5 opinions that were written. 7:6, 7 judges who formed the majority said, you can amend the Constitution. What was decided in Golaknath, that Article 13 includes Parliament's power to amendment as ordinary law, is not correct. Parliament has the power to amend the Constitution, there is no doubt about it. But you cannot amend the Constitution to destroy the Constitution. You cannot abrogate the Constitution, which means that amendments can be made, but otherwise you cannot nullify the Constitution. What does this abrogation of Constitution mean? Which means that there are certain essential elements in the Constitution which you call them basic features, basic structure, etc. Those cannot be touched. That's what has been decided by the majority. The other 6 judges said that where is this restriction you are reading into Article 368? If the word amend is used, that word amend also takes into its fold repeal, rescind, abrogate, destroy, demolish. Anything can be done by the Parliament. Where is this Parliament coming from? They are representatives of the people. So if the people feel that they want to demolish or destroy the Constitution, let them do it. That's a minority opinion. Now, after this opinion was delivered by the 7 judges bench, the debate started as to what are these basic features. In the judgment itself, you'll get an indication, the preamble that you're seeing is the basic feature. What is this preamble? This preamble contains the soul of the Constitution. What does it say? That we are constituting ourselves to be a sovereign, socialist came in the 42nd Amendment, secular democratic republic. And what we guarantee to ourselves is justice, liberty, equality, and fraternity. All these words are pregnant with meaning. They are not simple words. You just see justice, social, economic, and political. Justice is not justice that is done in court. Justice, social, economic, and political. Social justice, you must have heard. Political justice and economic justice. And when you are speaking of liberty, liberty of thought, expression, belief, faith, and worship. Every religious minority should have a right to practice his own religion. Every person should have a right to speak out. Every person should have a right to develop himself into a complete individual. Liberty. Liberty is something which is very important for the existence of a human being, a meaningful existence. It speaks of liberty of thought, expression, belief, faith, worship. Equality. Equality is something which we have been talking of, which we are very proud of in this country, but I am not very sure whether there is equality in the society even today. All of you must be seeing that still there is a disparity in the treatment of individuals. That's the reason why initially I said that we will have to raise about all these. So it speaks of equality of status and opportunity. It also speaks of promoting them all. And the last one, which is the most important provision here, is fraternity. People don't speak about fraternity at all. What does fraternity say? Fraternity assuring the dignity of the individual and the unity and integrity of India. Fraternity is universal brotherhood. Fraternity is all of us thinking that all Indians are one. And then the unity and integrity of India. We only speak of fundamental rights, we don't speak of fundamental duties which is there in the Constitution. None of us speak of our duties. We only speak of our rights, we want to enforce our rights. That's for a debate on a later occasion if at all it arises. So this is the basic structure. The goal is the preamble, how this country should be governed. Apart from this, there are so many other basic structures which have been culled out by the court, which cannot be touched by the parliament. What are those? Supremacy of the constitution itself, which means that the constitution should not be done away with. Constitution is supreme. You have three wings. All of you know as law students and even citizens know that this country would be governed by three wings. You have the parliament that makes laws, you have the executive which carries out laws, you have the judiciary which decides as to whether the laws are correct or not. Apart from that, all disputes that are brought before the judiciary are decided by the court as to whether the executive is right or not. So there are three organs in this state. Judicial review, that is the right of the court to look into laws made, has been found to be a basic structure or a basic feature of the Constitution. Right to vote, because of this country being a democracy, that is a basic feature of the Constitution. Likewise, there are so many basic features about the country being secular, coming from the preamble again, and so many aspects which have been dealt with by the courts are basic. What do you mean by basic feature? Basic feature is where the Constitution cannot survive without these amendments, without these features, essential elements of the Constitution. The questions that were asked by the courts when they were dealing with this basic feature doctrine, which I will come to just a little later, is this, as to whether the Constitution can survive without these provisions or not. So what happened after the Keshwananda Bharati? Keshwananda Bharati's judgment came sometime in 1973. In the meanwhile, elections were conducted to the parliament in 1973, 1972. Indira Gandhi won from Uttar Pradesh, in a constituency by name Rai Bareli. She won over Raj Narayan in the elections. Raj Narayan challenged her election on the ground that there are corrupt practices that were committed by her. What are these corrupt practices? He said that she utilized her people working in the Prime Minister's office and the offices of the state of Uttar Pradesh and spent more money than was permitted in the election. The Allahabad High Court declared the election as void, set aside the election of Indira Gandhi. And she carried the matter in appeal before the Supreme Court. And it was vacation time. All of you know courts don't work in vacations, and the Supreme Court was having a vacation judge, and in those days only one judge was sitting in the vacation judge, Justice Krishna Iyer, whose name you must have heard. I was just told he is one of the founding organizers of this AILU. He was sitting in the vacation court, and Indira Gandhi asked for a stay, a complete stay of the judgment of the Allahabad High Court. He passed an order of a limited stay where he said that you can participate in the proceedings in the parliament, but you will not be permitted to vote. Actually, that was the starting point for everything. He said, we're not going to now give a complete stay of the judgment. We'll just permit you to participate in the parliament. That was the order that was passed. So what did the Prime Minister do, the then Prime Minister? She wanted to retaliate, and that's how there were two amendments that were brought in to the Constitution. That was 38th Amendment and 39th Amendment of the Constitution. 38th Amendment gave power to the President to declare emergency in this country, and that emergency cannot be looked into by any courts. No court can interfere with an emergency. And 39th Amendment, the election to the posts of President, Prime Minister, Vice President and Speaker are put beyond the pale of judicial review. No court can look into the elections of these four persons. So they can do whatever they want and get elected, or nobody should challenge. 39th Amendment was again challenged in a very famous case, which is now Indira Nehru Gandhi versus Raj Narayan. To start with, the lawyer community was looking at the constitution of the court. They thought that this might not come out very well. By that time, emergency also has come. 4 judges who were in the minority in Keshwananda Bharati case were on the bench in Indira Nehru Gandhi in the case which was taking up the validity of 39th Amendment. What did 39th Amendment do, which I just told you? It declares that these people's election, Prime Minister's election, cannot be challenged anywhere. Number 2, no court has any power to go into these election matters of these 4 persons. On the ground that voting rights of individuals are a basic feature of the Constitution, 4:1, Justice Bhagavati was in the minority. The other 4 judges held that the 13th Amendment was unconstitutional, though the election appeal was allowed. So Indira Gandhi's election was upheld. We are not concerned with that, but the 39th Amendment was declared as unconstitutional by the court. What happened after the judgment of Indira Gandhi would be making a very interesting story for you all. This is something which most of you would not be knowing, because this is what was happening in the Supreme Court long time back. Chief Justice Ray was made a Chief Justice by Indira Gandhi by superseding senior judges, because they were in the majority in Keshwananda Bharati. Normally, Chief Justices in Supreme Court are made Chief Justices on the basis of seniority. Chief Justice Ray suddenly constituted a bench 2 days after the judgment of Indira Gandhi. 13 judges were sitting in court. Most of them didn't know why they were sitting there. They said that the judgment of Keshwananda Bharati is going to be reviewed. After 2 days of argument, Mr. Palkiwala made arguments for about 2 days, and then Chief Justice was asked by one judge sitting there, how was this bench constituted? What was the reason for the constitution of this bench? Who asked for the constitution of this bench? Then Chief Justice Ray asked Palkiwala, you asked for review. Palkiwala said, no, why would I ask for a review? I succeeded in the matter. Then he said, State of Tamil Nadu filed a petition for review of the judgment of Keshwananda Bharati. And the Advocate General of Madras High Court, Tamil Nadu, who was there, he said that I didn't ask for a review. Then the Advocate General from West Bengal, he stood up and said, none of us filed an application for review. Then all of them went back. Next day morning, all the 13 judges assembled, and Chief Justice Ray said, we are not going to take up the matter. So an attempt that was made to review the basic structure doctrine ended like this. But the relentless struggle of the government in trying to get supremacy did not stop. The 42nd Amendment came And the 42nd Amendment was brought by Indira Gandhi again with a number of articles, again taking away the power of the court, saying that the Parliament would have the right to amend the Constitution. Article 368 itself was amended by bringing in subclause 4 and 5. There are a number of articles that were issued. This was on the basis of a recommendation made by a committee called the Swaran Singh Committee. Indira Gandhi lost election after the emergency, but came back again in 1979. And this 42nd Amendment was again challenged, and Palkhiwala had to come back from America to argue this 42nd Amendment. One thing which would be interesting for all of you to note is the names of persons which I just mentioned about Keshwananda Bharati. Keshwananda Bharati is a monk in Kerala. He has nothing to do with this case. He just lent his name, and Palkhiwala argued that case. Likewise, now comes 1982 Minerva Mills. Minerva Mills had a case where the Sikh Industries Undertaking Act was challenged and it was lying somewhere. That was taken up, and 42nd Amendment was challenged, and Palkhiwala argued that matter and succeeded in the court upholding his arguments that the power of amendment that is conferred on the Parliament is not limitless. And it was held in that judgment that the limited power of amendment itself is a basic structure. If you transgress this, and if you go on amending constitutions and changing the nature of the character of the constitution, that's not permitted. I was hearing a lecture of Justice Rohington Nariman, where he spoke for the 10th Palkhiwala Memorial Lecture. Justice Rohington Nariman is an extraordinary jurist. I have seen judges and judges while practicing law and being a judge. But there are only a few people who can be called as legends, and Rohington Nariman is one. He was associated with this case, Minerva Mills. He just joined the bar and he was assisting Palkhiwala in this case. He was speaking in that lecture. Palkhiwala, while arguing, was, it seems, giving a few examples as to why the basic structure should be a feature for the constitutional amendments to be made by the Parliament. It seems he asked the court, if Parliament has the power to amend the Constitution in the manner in which it likes, and if the Parliament decides that we will bring in some ruler like a Mughal emperor or somebody, and then say that we'll hand over the country to that ruler, they can do it because they have the power to do it. Or they say that we will change the entire form of the government. We are following the Westminster form. Or they'll say, if the Parliament says Article 21, which protects the right to life of individuals, it says we're doing away with this Article 21. If it is permissible, then what would happen to the citizens of this country is the question that was posed. I am told that Minerva Mills case, which decided, has also decided, as I already said, that the balance between Part 3 and Part 4 of the Constitution, which are crucial to the running of this Constitution by themselves, are a basic structure of the Constitution. And thereafter, there were several several amendments that were made to the Constitution. I should mention that any law made by a legislation will be tested on grounds of judicial review, because the power that is exercised by the Parliament there is legislative power, it's not constituent power. Whenever there's an amendment to the Constitution, it is the constituent power of the Parliament. Whenever there's an amendment to the legislature, it is the legislative power of the Parliament. There were some amendments that were made. I think even this state also would be concerned with one amendment. There is a provision in the Constitution, Article 371D. Article 371D gave power to the President to establish a tribunal to decide service matters in the United State of Andhra Pradesh. There is a provision in that Article 371D, which is 371D5, which says the tribunal will decide a case, and thereafter, if the government doesn't like it, it says that we can ignore it. So they can overrule the judgment of the tribunal. That was found to be violative of the basic structure, and Article 371D5 was declared as unconstitutional in the case of Samamurthy versus Union of India. There was another case which came about setting up of tribunals, administrative tribunals in Chandrakumar, where the judicial power of the High Court has been taken away when that was declared to be unconstitutional by the Supreme Court. So basic structure is something which the court has been taking resort of to protect the judicial review and the right of the citizens to go to court and get justice. Something similar to what happened in our country when Indira Gandhi lost the election, she made laws, is happening in Israel now. For most of you who might be following the newspapers, you might be knowing that there's a turmoil in Israel. For some of you who might not know about it, I'll just tell you about the background. Israel has no written constitution. The parliament in Israel is called the Knesset. There are basic laws that are made in Israel, which is not the constitution, which govern the power that is given to the government to make laws. The Prime Minister now, Netanyahu, is on a slender majority. In the Knesset, he has a majority of 64:56. 56 are the opposition members. He stitched up a coalition and is continuing. There are criminal cases that are pending against him of corruption, etc., in a magistrate's court in Jerusalem. So he came out with this idea sometime in March of 2023 that the power of the Supreme Court has to be somehow or the other curtailed. So he thought that he will make an amendment to the basic laws, something like our constitution, whereby he would include a clause which is called an override clause, which means that the court will pass a judgment and the Knesset, which is a parliament, would sit and say, it's all right, we are overriding this. So the judgment is of no use at all. And he also wanted to interfere with the appointment of judges. In Israel, there is a judicial appointment commission which consists of 9 people. Unlike in India where judges, they have a collegium where they select judges, there is a judicial appointment commission. In that judicial appointment commission, 6 persons are either from the judges or from the fraternity of lawyers, which is the advocates. 3 are from the executive. So the majority is from the judiciary and the legal profession. So he wanted to reverse that. He wanted to have more people on the executive so that the selection of judges would be in the hands of the executive, and the executive can have its own persons as judges who would not rule anything against the government. It so happened in Israel that the awareness of people was carried out by certain democratic institutions, and there was an agitation. The citizens of Israel started taking to the roads. Every Wednesday, there used to be some sort of a demonstration where people were saying that citizens' rights have to be protected. These demonstrations continued for about 36 weeks. It was almost reaching a crescendo at some point of time. About 3-4 months back, I got a call from Israeli Democratic Institute, which has been there from 1930. They wanted me to go and then speak about democracy and how the constitution works in India and what is this basic structure principle. So I went to Jerusalem. Before the conference took place the next day morning, in the evening, I was told by Professor Yaniv Rosnai, he is a person who did his research on basic structure and has written a book on basic structure. He said, Justice Rao, let us go and lives to lead. So I just picked up an elderly couple of about 60 years. I just stopped them and asked them, what's the problem? Why is this demonstration going on? They told me, 5 minutes they explained to me, what is this override clause? How is it affecting the rights of citizens? If the power of judicial review of court is taken away, what would happen in a democracy? So it would become a dictatorship. Then I asked them, what do you do? One of them said that he's a carpenter. And his wife said that, I don't do anything, I'm a housewife. This is the level of awareness and consciousness of the people in Israel. After the conference was over, midnight I got a call saying that, Justice Rao, you have to leave early in the morning because tomorrow there is going to be a complete Bandh of Israel. I reached the airport, all the flights were stopped. With great difficulty by evening I somehow or the other came out. But what made me think was this. Acting like this, all of us are very well educated, all of us know that we have rights to protect, all of us know the importance of the Constitution, but still we do not question because we haven't learned to question the importance of basic rights. That. There were discussions. In Israel, the defense minister was against these amendments. In Israel, there is a problem between the Jews and the Arabs. There's always a problem in the Gaza Strip. It continues, and then there is some sort of a internal strife which is going on. The Attorney General of Israel, unlike our Attorney General here, is an independent trial, said that this legislation is not correct. She didn't support the government. Like a government leader, can the government leader say government is wrong? She said no. What is being done is wrong. The defense minister said no. The president said no. President is a nominal president there. But still, the prime minister wanted to proceed. In spite of such demonstrations, he made law. The Knesset made law in June. The law, though has been scaled down, is to the effect now that though the Supreme Court has power of judicial review over parliamentary legislations, it cannot set aside any legislation on the ground that it is unreasonable. So, which means that you are clipping the wings. It says that your powers are restricted. The second one is relating to exactly what Prime Minister Indira Gandhi did then. Netanyahu has brought out a law by saying that the Knesset would decide as to whether a person should be the Prime Minister or not, in spite of cases being there against him, because the Attorney General was saying that you should not be the Prime Minister because there is a criminal case against you. So he brought out that law also to ensure that he will not be sent out, trying to protect himself. These two laws were challenged in the High Court of Justice, as they say in Israel, which is the Supreme Court. The Supreme Court there has 15 judges. The questions that were put by the judges make interesting reading. So the judges were trying to ask the advocate who was appointed by the Prime Minister, because the Attorney General was not supporting the government, there was a private lawyer defending the government. So the questions that they were asking the lawyer appearing for the government were exactly the same questions which were put to the Attorney General of India when Keshwananda Bharati was being heard, or Minerva Mills was being heard, or Vaman Rao was being heard, as to what would happen to the citizens. You do not want somebody or some organ to become so powerful where the balance would not be there. We do not have separation of powers in this country. Separation of powers is only spoken of in judgments. You have three wings, each of them trying to take over the other. There is the parliament wants to make laws and then say that court should not interfere. And court would be saying that this parliamentary legislation is not correct. Parliament doesn't like it. executive decisions are interfered with by the court day in and out. The executive doesn't like it. Passes an order, court says stay. So they would say that how is it that we can run the government? I'll tell you an interesting incident without mentioning names. Before I became a judge, I was a law officer in both the governments, Congress and BJP. I was an additional Solicitor General. So one law minister who was a seasoned lawyer earlier, very seasoned lawyer, one of the stalwarts practicing now. He was a law minister, and then the right of privacy case was going on. The Aadhaar card case just started. I was asked to defend the government of India. I went and told him the judges are putting such inconvenient questions. What do we do? For a marriage registration, it seems Aadhaar card is being required to be shown in Bombay. This is about 10 years back, not now. All of you got used to all these Aadhaar cards now. Those days, people were agitated as to why Aadhaar for everything. So I was told by the law minister that what do the judges think of themselves? We are running the government. We know the difficulties of people. We are all elected by the people. Why should they start interfering with this? The same person who was a lawyer earlier, a lawyer now. So when you are there in the parliament, your perspective changes. When you are in the executive, you think otherwise. So when parliament makes legislations, what it does is, it definitely carries out the wishes of the people. In the United States of America, there is a principle called a counter-majoritarian difficulty. Alexander Hamilton wrote a book, The Least Dangerous Branch. He said that the least dangerous branch in the government is the judiciary, because it neither has the purse nor the sword. Purse means it doesn't have the money. For the money to run courts, judiciary has to depend upon the executive. Ultimately, money is sent by the government for the High Court to run here, and the salaries are paid by the government. It doesn't have fund on its own. It doesn't have the sword also, which means it passes an order, it passes a judgment which has to be implemented by, again, the executive. If the executive says, I'm not going to implement, again, contempt powers, etc. are there, but the judiciary doesn't have policemen, or judiciary doesn't have army for implementation of its orders. That's the reason why Alexander Hamilton said that this is the least dangerous branch. But when the US Supreme Court started interfering in legislations from 1905 to 1930, in most of the legislations on grounds of judicial review and the due process clause, which we don't have in India, they have started some sort of a philosophy. Parliament is represented, they're representing people. They know what they want. So you do not have the right to say Parliament is wrong. You should defer to the wishes of the Parliament. 9 judges sitting in the US Supreme Court, they can't say is wrong on due process. So this is one theory there. Now, I come to the final portion of revisiting the basic features. All these years, people were not talking about basic structure. All of a sudden, there's a debate on basic structure for the past 1 year. How has it all this started? We have some constitutional functionaries, I am again not going to refer to them, who started saying Keshavanand Bharati is wrong. So some judges started defending, some legal professionals also started defending, saying, oh, what is wrong with this? So everything is all right for these years, 73 onwards till 2023. Everything was going on smoothly, government was also happy. So suddenly, why this debate? The debate is because, again, the parliament wants to make some laws, take them out of the reach of the court. Again, revisit the debate that was there about 50 years back, because it's 50 years after Keshavanand Bharati was decided by the Supreme Court. The problem in this country, as I see, constitutional functionaries do not stay within their limitations. We have speakers, after becoming speakers, towing the line of political parties. Day in and out, you might be seeing the speakers speaking on behalf of the ruling party, making comments in favor of the ruling party. There are no more independent. You have governors who have also been exceeding their briefs I'll tell you about one case which I decided. This is the Rajiv Gandhi assassination case. A bail filed by a person by name Perarivalan came before me. He has been in an independent view except for when he exercises powers as a chance functions like that. 2 years he sat on the file. Perarivalan continued to be in jail. Petition is governor has an immunity, president and governor, but still we have ways and means of getting an order passed and then directing the office of the governor through the state government to act. That's a judgment of the Supreme Court in Rameshwar Prasad. So with great difficulty, we made the governor take a decision. And what is the decision that he took? After 2 years, the decision taken by the governor is that I will refer this matter to the Union of India. The Union of India will now decide. A decision taken by the state government for which either he has to give approval, not either, he has to give approval. He says, now I'll send it to the Union of India, let them. It's very easy. So if I have to take a decision, I can escape by saying, this is called passing the buck. So the file goes to the next table. I need not take a decision. And we had to take an extraordinary step. Normal course, we won't do it. But under Article 142, a power that is given only to the Supreme Court of India under the Constitution to pass orders to do complete justice, I thought it is high time that he comes out. So that's the reason why we released Perarivalan. And after Perarivalan release, the other, whether you are the Chief Minister, whether you are the Prime Minister, and whether you are a person who are a laborer, when you are talking about that equality, which means equal protection of laws, applicable of laws to a person. Merely because you are accused of a grave offense, it doesn't mean that you are not going to get. Something that all of us have to be the first one to raise your voice and bring it to the notice of whoever the authority is. I'm not saying you should suffer anybody. You must be facing a number of persons who are unreasonable. Unreasonableness is not a ground to say that he has been misbehaving. But if at all he is crossing a line, definitely you should take it to the notice of whoever is in charge. The level of debate as it has come down in the political sphere is coming down in public life as well. So when you have people sure that AILU will continue the endeavors which it is doing now by having seminars like this, you're going to have Justice Muralidhar, who is an extraordinary judge who is going to address you in the afternoon. Justice Rajni is going to speak to you in the afternoon. I'm sure that all of you would enjoy listening to them. I'm also sure that I've shared my ideas and some of them are interesting also to you. And I hope I have been able to communicate myself well. Thank you so much for the patient hearing.
It gives me an immense pleasure to thank Sri Nageswara Garu because the object basing on which we thought of organizing this seminar is fulfilled. And I hope that everyone in this hall has understood, and all of us should understood that it is the only lawyer who can be a torchbearer of the society. And it is the preamble of the Constitution which is leading all of us. So an immense duty is also cast on the advocate community to see that the rights of the public are to be protected, for which our services are needed more. I thank Sri Justice Lau Nageshwara Garu and the example which he has referred, the recent Israel example is also to be kept in our minds, that in future there may be such type of situations, those may arise in our country also. So let us be alert. That is the caution that was given by, that has been given by our speaker today. So I, and on behalf of all India Lawyers in Telangana committee and all the audience of the hall, I thank Sri Justice Lau Nageshwara Garu for giving an extraordinary and outspoken opinion of him with regard to need of, written by Sri Justice H.N. Nagamohan Das Garu, former Judge, High Court of Karnataka, basing on the working of constitution which was written in English. Now it is being translated version of Telugu is being to be released by Sri Justice Lau Nageswara Garu, and I am supposed to or I am duty bound to say that Justice H. N. Nagamohan Das Garu has printed 1 lakh books of on the constitution, working of constitution, and he has addressed 10,000 of meetings basing on this working of constitution and requested the people to save the constitution. So today we are fortunate that Sri Lau Nageshwara Garu releasing the Telugu version of working of our constitution.
ఆ స్మాల్ అనౌన్స్మెంట్ ఏంటంటే ఈ బుక్ ఖరీదు 100 రూపాయలు, ఈరోజు 50 రూపీస్కి కొనుక్కున్న వాళ్ళందరికీ ఇవ్వబడుతుంది. కాబట్టి అందరూ కొనుక్కొని చదివి సర్క్యులేట్ చేయమని విజ్ఞప్తి చేస్తున్నాను.
One more assignment, sir. On the eve of, please, on the eve of this seminar, AILU Telangana committee has conducted an essay writing competition to the law students, and we have chosen 9 law students who have written the essay which is befitting to the today's topic of the seminar, and I request the organizer Nisa Fatima to come and read out the names of the winners of the essay writing. Nisa Fatima, please come. And I request Sri Lau Nageshwara Garu to present the small prizes to the winners.
I would like to explain, like, there are few of the essay which have been selected. So those selected essay candidates have been here for the distribution of the certificates from our chief guest. So the first one is Apurva. If she can come on the dais to collect her certificate. The second is Sonia. Yeah, Sonia. Shamshita. Shailaja. Bushra. I am Bushra Fatima. Then
Fortunately, this competition was conducted among all the students, but only lady students are more enthusiastic, and they have. That's what our chief guest is also asking, whether this competition is meant for only lady students.
Shahana.
And I request Fatima also to receive.
Yeah,
Sir.
sir.
Okay, thank you.
Thank you so much.
I request Sri D. Praveen to come and offer a vote of thanks, and before that I request our Secretary Parthasarathi Garu to and M.V. Durga Prasad Garu to come on to the dais to present a small, it's not a memento, these are books we are presenting to the chief guest and also the guest of honor. And I request Durga Prasad Garu to present another not memento books to the other guests, Sri A. Narasimha Reddy Garu also. Vote of thanks by Mr. D. Praveen.
Respected guest of the seminar, Sri Justice L. Nageshwar Rao Garu. Before elevation to the Supreme Court, Nageshwar Rao sir is the founder, president of AICA, that is All India Advocates, High Court Advocates Association. I am also been part of the AICA from AP High Court. Sir, your keynote on revisiting basic structure of Constitution gives us immense aspiration to strengthen the democracy, socialism, secularism, and justice. I, on behalf of Telangana State Committee, All India Lawyers Union, we thanks to Sri Justice L. Nageshwar Rao Garu, and also I thank our President Koli Satyanarayana Garu, and also thank our General Secretary Sri K. Pathar Sarthi Garu, and also I thank all the organizers and A. Narasimha Reddy Garu. He is our eldest brother since from 2005 onwards. He is associated with the AILU, and also I thank all dear participant, students, media, and also fraternity from all District Bar Association advocates. Thanks one and all.
మిత్రులారా, ఈ లంచ్ ఇప్పుడు ఉంది పైన 3rd ఫ్లోర్లో. అందరూ భోంచేసి వచ్చి మళ్ళీ ఇక్కడే కూర్చోవాలి, ఎందుకంటే సెషన్ స్టార్ట్ చేయబోతున్నాం.